Okay, well, it's noon now, so let's get started. Hello, good afternoon, and welcome everyone to our webinar, Current Trends in Damages Assessments, sponsored by Bergeron Clifford Personal Injury Lawyers and hosted by LexisNexis Canada. I'm your host, Timon Sisek, and we're going to jump right into it today. So, as personal injury lawyers and lawyers practicing in litigation in general, the question from clients, how much can I expect this to be worth, is of course standard fare, rivaled probably only by the question, how long will this take? As such, a discussion of damages trends is pretty much always timely for a plaintiff litigator. There's a lot to cover today, so we'll be jumping in shortly. Some of the topics we're discussing today will be looking at the recent clarity in trends, or perhaps lack thereof, in claims under the Family Law Act, non-pecuniary damages, and estimating economic losses for irregular employment and what's colloquially called gig workers. We'll also have some reminders for what to look out for with dealing with collateral benefits as well. And before anyone asks, of course, today's presentation is accredited for 1 hour of substantive CPD credit, because you're going to be learning a lot today. And just before I introduce our panelists, we'll be asking that you turn your attention to a Zoom poll that's going to pop up on the screen. And I'll give you about 30 seconds to just take a look at this, and if you could make a selection here. Love seeing the numbers just bouncing up and down and the bars moving around. Like watching a horse race. Okay. As folks are finishing that up, I'd like to introduce our panel. With us today are a panel of experienced lawyers from Bergeron Clifford Injury Lawyers. Bergeron Clifford has been consistently ranked amongst Canada's top 10 personal injury law firms, with over 25 years of experience in and out of the courtroom. Whether it's a brain injury from a car accident, medical malpractice, or any other type of accident, they provide trusted legal advice with compassionate client-first approaches. Their team has offices across Eastern Ontario, including Ottawa, Kingston, Carleton Place, Pembroke, and Perth. If you'd like to learn more, visit www.bergeronclifford.com, and please feel free to reach out to the firm for collaboration or referral opportunities at injurylaw@bergeronclifford.com, or call 1-866-384-5886. That's 1-866-384-5886. We'll post that information in the chat description below as well. So first up is, of course, none other than Mr. Chris Clifford. Chris joined forces with Ted Bergeron in 1999 to form Bergeron Clifford Injury Lawyers, and in the past 26 years has successfully represented injured clients and their families throughout Ontario. He's appeared in the Ontario Superior Court of Justice and before the Financial Services Commission of Ontario, Criminal Injuries Compensation Board, Workers' Compensation Board, Social Benefits Tribunal, the Canadian Pension Appeals Tribunal. He is also, of course, a Law Society certified civil litigation specialist. Our next speaker is Joseph Dart. Joe is a partner at Bergeron Clifford, and he began his career as a Crown prosecutor, actually. He joined Bergeron Clifford in 2015 and represents plaintiffs in negligence, medical malpractice, and automobile cases. He has tried and argued cases before the Ontario Superior Court of Justice, the Ontario Court of Appeal, along with the License and Appeals Tribunal, the Social Security Tribunal of Canada, and Workplace Safety and Insurance Appeals Tribunal. He is also a Law Society of Ontario certified civil litigation specialist. And also joining us today is Warren Whiteknight. He is a partner at Bergeron Clifford Injury Lawyers as well, of course. Warren practices throughout Ontario and North America, but his particular focus is in Eastern Ontario. He is a past president of the Frontenac Law Association and he often teaches as an adjunct professor at Queen's University Law School. And I'd be remiss not to say that he is also an LSO certified civil litigation expert. So let's kick this off. We're seeing some interesting appellant guidance lately on how non-pecuniary damages, such as loss of care, guidance, and companionship, are being quantified. There's still considerable variation across jurisdictions, but a push towards greater consistency has also emerged. I myself, in preparing for this webinar, I thought I'd take a look at Lexis Plus AI to see what kind of answer I would get before I start asking the experts here. So I'll just share my screen and show everybody what I found. We'll keep this brief because, of course, we have the human beings here with human expertise. Oh, excuse me, wrong screen here. Of course, it wouldn't be a webinar without some technical difficulty. That up. Okay. Great. Come on to the panelists. Let me know if you see my screen here, and should be the Lexis Plus AI screen.
Yep, we got you there.
Okay. Okay, excellent. Thank you. So here I've just asked, can you highlight any recent case law that has emphasized a push towards a more consistent approach to damages for loss of care, guidance, and companionship and other non-pecuniary losses? Specifically focus on cases dealing with fatality claims under the Family Law Act. And it says yes. I won't read out the rest of this answer, but we do notice that there's this cite this case Moore versus Numbered Canada Company in the Ontario Court of Appeal. There are some other details here from our practice notes, but of course, again, because we have an expert in this field on the call, I'll pass it over. I'll stop sharing my screen here to Chris. So Chris, can you give us a bit of a background on how courts have traditionally approached non-pecuniary damage under the FLA and what's changing now?
Sure. Thanks, Timon. And it's not lost on me that you're asking the old guy for the history. The days might be long, but the time has gone fast. I think when I first started practicing, 26 years ago now, these cases were particularly difficult because you'd meet with a family, who's suffering a tragic loss, and you'd have to explain to them that we couldn't get them anything for their pain and suffering, and that the courts recognized the loss of the relationship, but only in a modest fashion. And we tended to emphasize the process and the fact that I'd be able to get answers for them, which was often very important as part of the grieving process, and that I'd be able to bring some closure, at least to that part of it for them. But bringing a claim, if there was no dependency loss or anything else unique about the case, if it was just that loss of care, guidance, and companionship, the claims were considered fairly modest. But with Toe, on to Fiddler, and now with Moore, I think the courts have evolved, and now they're not treating these as, I don't know if they ever treated them as trivial, but there's substance to it now. There's more meaning to it. And with the Moore decision, for those that aren't familiar with it, the parents received $250,000 each for that loss of care, guidance, and companionship. And I think that's considered now the new high water mark.
Mm-hmm.
Yeah.
Okay, and so do you think, can you speak a little bit more about how Moore has impacted the quantum of awards and the judicial thinking around the space, or it's simply just they've set the watermark and that's what we're looking at now?
No, I think there's been a general lift to the claims. I think the insurers are recognizing more exposure now than they did before. Now that decision is on the books. And when we get to a pretrial, judges I think they feel a little more freedom, a little more license to recognize higher awards. So maybe that's the best way to look at it, Timon, is just that there's been a general lift and a comfort level in negotiating at higher levels than there might have been 10, 15 years ago.
Okay. Yeah, there's that sort of general lift. Now, are we seeing a shift towards standardization, or is variability still a major factor?
Yeah, I was thinking about this, and because it's the cases themselves are turned on a case by case basis, there's still room for considerable variability. But I think with the evolution of the case law and with the passage of time, I would think I look at it as more of a standardized approach, more clarity in how these cases are considered and decided. So room for variability on the end results, depending on the facts, case by case, but a more standardized, recognizable approach and evaluation of the process.
Okay. And with that in mind, what kind of practical advice would you be giving perhaps younger litigators quantifying these losses today, or any litigators for that matter?
Sure. Well, the first thing I'd say is review the case law. So that Toe and the Fiddler and the Moore decisions, within an hour, if you read those cases, they'll give you the roadmap on what the courts are looking for and how they're approaching the cases. And I do the same. So it just anchors you, and you get to see and remind yourself about what you're going to need to do going forward. And after that, there's a deep dive into the facts of the case. You're looking for the uniqueness to the relationship, how often they spoke, Thanksgivings, birthdays, texts, emails. Is there anything unique about the case? So you've got to take a deep dive on the facts, and then you can step outside the box on the experts that you use. In the Moore decision, for example, I think it was a psychiatrist that they used to provide expert opinions on what that loss meant and the impact long term that it was going to have. Our firm, we've used, there was a social worker that we used who had extensive experience in grief counseling. We used that particular expert to talk about, in the appropriate cases, the uniqueness of the loss. So if it was an elder who was carrying the traditions of the family and the culture, the history of the family, and that particular loss, through this expert, we were able to articulate, provide the evidence the court needed to talk about the particular impact that had, particularly with respect to children, passing down these traditions and that knowledge in the community. So being able to step outside the box, once you understand what you need to do, is something that is helpful.
Yeah, that is very interesting. We often talk about sort of cultural sensitivity and how different or cultural appropriateness when interacting with our clients, but this is a great example of where it's going to have a dollars and cents impact, right? Ultimately, so that's a really good insight.
Yeah.
Okay, I'd like to talk a little bit. Sorry, go ahead, Chris. Sorry.
No, I was just I was thinking in these particular claims, and we're talking about the loss of care, guidance, and companionship. It's important to keep in mind that there is no legislative cap and there's no judicial cap, and that the other thing you can think of is in a case where you like the liability and the damages, you want to make sure that there's a jury award, or a jury notice, because juries are more likely to stretch that upper limit. Judges don't want to create grounds for an appeal, for example, so they're unlikely to go beyond that upper limit in a decision. But the Moore decision was jury, and they exceeded it by a fair bit, but not overturned by the Court of Appeal. So don't take for granted that the defense is going to file that jury notice for you in a case where you really want to have one.
Okay. And could you repeat what was that trilogy of cases you mentioned? It was Toe.
Oh, yeah, I was talking about the Toe versus Toronto School Board. Fiddler was another one that sort of came after that. There's cases in between there, but for me, in my practice, there's sort of my benchmarks. And then, of course, Moore now. And Moore came out, 2021 was a Court of Appeal affirmation of the original judgment. So there's been a bit of time since then. We talk about $250,000 for each parent, but if you apply inflation, it's just shy of 300 now. So,
Right.
not insignificant anymore.
Okay, well, and speaking of inflation, we do want to talk about inflation here. So the next topic we'd like to look at is whether courts are adjusting general damages caps in order to account for inflation. So again, I do have our little plug here, so bear with me, everyone. But I asked that question to our AI as well, and asked, are courts adjusting the Andrews cap to damages in order to account for inflation? The first answer here, I like this point first answer, yes, and then continued on with the explanation. Of course, we have some cases here. Just thought people might want to take a look at that. But that being said, I'll turn it back over to Warren and just ask Warren, where does the Andrews cap stand today, practically speaking?
So I think everyone here will be familiar with the fact that the Andrews cap was set in a trilogy of cases as well back in 1979, set originally at $100,000. And that's adjusted for inflation every year. It's important that everyone's aware of the basis of that, which is the Terneuzen case from Supreme Court of Canada, 1995. So it is the law that you're supposed to adjust awards for inflation. And there's two quick and easy ways to look at that. So McKellar's has a nice calculator that's right on their website. They also publish the updated caps for the Andrews cap, as well as FLA damages and things of that nature on their website. But the Bank of Canada has an online inflation calculator that's really useful for quick benchmarking of cases. So I use that regularly. So the Andrews cap set 1979, $100,000 is roughly $465,000 today. So it's, quite a bit larger than obviously the original 100 grand.
Okay. And are courts adjusting that inflation explicitly, or is it so they're taking that into account when they?
Yes, absolutely. So when you read through all the case law, oftentimes, so what we do and what you'll see in the decisions is when you're presenting precedent cases to a judge, usually for the purpose of making a charge to the jury, say it's a motor vehicle accident case, then you're taking, your 2007 case, your 2012 case, your 1995 case, whatever it is, and then updating those amounts for $2025 and presenting them to the judge, asking them to make a charge, in a range of X to Y to the jury. And then, depending on what the judge feels, then that charge will go. But yes, the inflation is being implicitly and explicitly calculated into those awards.
Okay. So, and on chronic pain and psychological injury cases, how have they fared in recent years? And are we seeing more recognition of invisible injuries? And if so, how does that affect those damage quantifications?
So these cases continue to be very challenging. They are, I think all of us who practice in this area are aware that, if you have someone in front of you who has suffered what insurers think of as an objective injury, so, fractured humeral head or a tibial plateau fracture, something that has an open reduction internal fixation surgery, these are what insurers think of as objective injuries. Generally, we are more comfortable as PI lawyers in quantifying these cases and in giving clients an assessment early on in a case. Okay, so you've got a fractured C5 wedge compression fracture with 30% loss of vertebral height. I'm going to put that at $225,000 with the resulting chronic pain. And same thing for a mid-shaft tibial fracture with an implanted titanium rod or whatever. You're gonna just eyeball it, and the precedence, and it's 175 grand or whatever it is. In the chronic pain cases, the psych injury cases is much more difficult because the case law is all over the place. We definitely have some really nice benchmark cases that have come out, and they're pretty consistent as you go back 15, 20 years. Like, I wouldn't say these cases are increasing in value, but when you look at old awards and update them for inflation, as we discussed, I think that the high watermark for chronic pain and psychological injury cases, people who have severe fatigue, depression, PTSD, et cetera, is still somewhere between $175,000 and $225,000 when it's updated for inflation. We've had a couple cases in the past few years that have been consistent in that regard. I was doing a little bit of research before this. So we've got Rolley, Rolley, and McDonnell, Macdonnell, 2018. It's $175,000 when adjusted for inflation for an MTBI, chronic pain, and this person had significant pre-existing conditions. We've got Higashi and Chiaro, so that's Higashi and Chiarot, chronic pain case with PTSD. And that's kind of a high watermark case there. It's 225,000 in 2021, so 262 grand today. So a really good case there to keep in your back pocket. Another thing to remember, I don't imagine that anybody on this webinar has a major practice in defamation or intellectual property cases, things of that nature, but there are some exceptions to the Andrews cap. So there are several explicit carve-outs that are not covered by the cap. So intentional torts such as sexual assault, not covered by the cap. Defamation cases, not covered by the cap. There's an interesting case, Cinar and Robinson, Cinar versus Robinson, where a guy had pitched a number of TV shows to a network. He was a big dreamer. He wrote these TV shows. They turned him down several times. And then 10 years later, he turned on the TV and recognized his own show on TV. So they'd stolen his intellectual property. This went all the way to the Supreme Court of Canada, and he was awarded an enormous general damages award. The cap at the time would have been roughly 345 grand, and he got 400,000 in pain and suffering. And the Supreme Court allowed it because his pain and suffering did not arise from bodily injury. It arose from theft of his material property. And so there are these unique exceptions. Again, sexual assault being one of them, pretty common for egregious cases of assault that you can get awards above $400,000 today. Same thing for defamation cases. There's the Hill versus Church of Scientology case from 1995 that is the general damages award in that case for defamation is now adjusted for inflation. It's 560 grand. So there are those unique carve-outs that people should be keeping in mind.
That's really interesting because I mean, intuitively, you'd imagine people think about the physical injuries as the big ones, right? And of course they are, but yeah, that's good to know about the excess of the cap.
Yeah. Two other things I wanted to mention quickly, resources for people. I think it's, Ontario obviously has the most cases out there. We just have the biggest population. And, that the rules consultations that we just saw said there's something like 66,000 new PI cases filed every year or something to that extent. So there's a lot of cases, but some of the best cases for pain and suffering in terms of plaintiff side perspective are coming out of BC. So don't limit your research to Ontario. A lot of the largest quote unquote invisible injury awards come out of BC. So important to keep those precedents in your cabinet. The other thing, I imagine a bunch of people will be aware of this, but you can go online and check out the CCLA damages compendium. So the Carleton County Law Association, every couple of years, they have law students that update an online repository of it's a compendium. So it's supposed to be a fairly complete representation of damages awards made in Ontario since the last publication. This thing's now about 700 pages long. And you can it's organized by body part and by injury type. And you can go through the awards for the past 20, 25 years and see what the ranges are.
And you had mentioned some awards from BC. We do have some questions about BC, but we'll leave Q&A for the end if we have some time. So for the person that posted that question, we'll try to get to that towards the end because it sounds like Warren has some comments on that. Warren, I did also want to, this is going back to you and Chris had mentioned juries, and I know prior to this webinar we were talking, you said that your firm employs a tactic of using jury studies. or mock juries. Can you tell us a little bit about that process and what benefits you find from that?
Yeah, so we've got a courtroom in our office, and you don't need one to do jury studies, but we do jury studies before any case gets ready for trial. And so our process is basically we put an ad out in LinkedIn, Facebook, the newspaper, whatever it may be, to hire jurors from the public. And we will run a mock jury on part of our case to better understand that case and how a jury is likely to react to it. So, a typical chronic pain case these days, if someone's got future care costs and an income loss claim, is going to take 3 weeks of court time. And, you can't do that with a mock jury. So what we do is we pick one part of the case that we're most concerned about. Maybe it's their credibility, maybe it's some pre-accident issues in their income stream. Maybe it's something to do with their future care cost claim. So we pick the part of the case that we're most concerned about. We will hire the jury. We make sure we screen it for demographics that we are likely to receive on our jury and demographics that we're interested in. So if we're interested in how, middle-aged women will react to our plaintiff or how retired men will react, we want to make sure we have that representative demographic on the jury. So we hire our jury, we sit them down for half a day usually, and we will put our plaintiff on the stand in front of them. We'll hire a defense lawyer to prep the case and to cross-examine our client on that aspect of the case that we're concerned about. And we usually put one expert on the stand. So if it's an economic loss issue, we'll have an accountant on the stand, future care cost assessor, et cetera. And then we will present the jury with a jury sheet, but it's not like the one you get at a trial. It really has some more kind of soft factors on it. How did you feel the lawyer's presentation went? Did you find the plaintiff likable, believable, credible? And then we do ask them questions like, how much would you award for pain and suffering if you were told by the judge that the range was, from $100,000 to $250,000 in appropriate compensation? How much would you award? What would you award for income loss or medical rehabilitation, whatever it may be? And then we leave. And we listen to them talk. We have the room wired for video, and we watch them and listen to them for the next couple hours in order to assist with our trial preparation. Some of the big takeaways we get from this, it won't be a big surprise to anybody, but jurors are very unpredictable. They also don't listen very much to the law or what the evidence actually may be. They talk a lot about themselves and their family members. They get very caught up on conspiracy theories and unrelated things. I think that some of the utility is in the lack of consistency that you can get from people. Oftentimes at the end of the day, we remind them that, you finished all the sandwiches, it's time to go home, and you still haven't filled out our sheet. We really need some answers there, and they just add up and divide by 6. So it's, a scary proposition to put a chronic pain case in front of a jury for that exact reason.
Yeah, and if nothing else, I mean, it gives your client the understanding that it's going to be like that, right? And
Yeah,
that's
we absolutely, we
value in
have our
itself.
client watch the video session with us, and they're always, aghast at the process. I mean, these real jurors can't be like this. So yes, they are. It's just the 6 people behind you in line at Tim Hortons.
That's excellent. Well, thanks for giving us a view into that. Okay, well, we're going to shift the conversation to the collateral benefits and the tort thresholds. Just before we do, I did want to come back to what we were talking about earlier with respect to economic loss and earning capacity, especially in the gig economy. So we're looking at some trends, particularly the claimant is self-employed or working in less traditional or precarious role. There's been an evolution in how contingency and future loss calculations are approached, especially with newer types of work with the emergence of gig work and content creators. So Joe, I'll turn this over to you. What do you think are the biggest hurdles in proving economic loss for self-employed or gig workers, and have courts developed any consistent methodology for assessing the future earning capacity of these individuals?
Thanks, Timon. And I thought you were cutting me out of the presentation already. I hadn't even started talking yet, but no, thanks for having us. So this is a sort of a loaded question. I'll take a little bit of time to come through it. The short answer is evidence. And I'll explain what I mean by that. But I think it's important that, regardless of what type of income loss claim it is, whether it's a T4 employee to a gig worker, the tests are the same, right? And it's important to remember the tests. So the test for proving entitlement to compensation for future income loss, of course, is that you only need to show that there's a real and substantial risk of that future loss happening. You don't have to prove it on a balance of probabilities. You don't have to prove it to any more stringent standards. So it's not an incredibly large burden. That being said, and one thing I can, we'll talk about trends in a minute, but the other important test on the flip side is that a question can't go to a jury. So a question about income loss can't go to a jury unless there's some evidence upon which that jury, acting judicially in the wording of the test, could reasonably make a finding that there has been an income loss and what that loss is. And what you're seeing is a lot of cases not going to a jury on this basis. And what that means is you have to have a proper evidentiary foundation before a jury can even be asked to decide on income loss. Usually you're going to look at, what is the evidence out there, both medical, lay witness, and work evidence, to determine whether there is a loss and sort of what that might be in the future. And then usually it falls on expert evidence to quantify that loss. So, in terms of like coming back to my original short answer, for a gig worker, putting this all together in a cohesive and sort of digestible fashion is not easy, because the very nature of the work is that it's inconsistent, right? So your work is going to be inconsistent, your income is going to be inconsistent, and proving that you're going to have steady access to that type of work over time is not going to be easy. So part of the question also dealt with self-employed people. That the law has sort of developed to a point where using averages over time, if there's enough data there, is something that you can do. So if a plaintiff has an average income earning history of, say, $60,000 or $70,000, despite the fact that their income might fluctuate between 30 and 100 during that same 5-year span, courts are usually okay to accept that as an average and use that as a base to calculate an income loss going forward. If that's not possible, if the records aren't good enough, courts have also allowed experts to testify about statistics. So Stats Canada puts out surveys and statistics reports annually about what people in different fields make, and experts can rely on this if the other evidence would support it to make findings on income loss. But there's not a lot out there for gig workers at this point. I mean, I looked through the case law, and we'll talk about one or two cases in a minute. But Stats Canada does have statistics for gig workers, but it's not very well documented. There is a large percentage of people who count gig work, apparently, according to Stats Can, as part of their employment, but it's usually not the main part. And the earnings are not exactly significant, at least at this point, based on that research. So there's a bit of a hurdle there because of the inherently unstable nature of the work in the first place. On top of that, you can't forget about the medical evidence, right? So, gig workers, you usually associate that with some type of short-term kind of office or computer related work that someone can do, usually at home or remotely, basically in one of the easier settings that you can find for someone who's trying to work. So the medical evidence required to prove that you can't do that is going to be more onerous than, say, obviously a laborer or something like that. So in terms of, cases and trying to help the audience sort of see this through world life examples, I found two relatively recent ones, and I think they both kind of paint the picture of what I'm talking about. The first dealt with a self-employed person, so not a gig worker, but a real estate agent. The case name is Grujic and Fine. The citation is 2024 ONSC 4877. So, like I said, not a gig worker per se, but someone whose income goes up and down pretty significantly. If anyone's ever dealt with real estate agents as clients, you know that their incomes fluctuate significantly. So in this case, the question was not allowed to go to the jury as to what this plaintiff would have or what their future losses were going to be when it came to her income, and it was based on a lack of evidence. So in sort of brief, she talked about how she earned money. She talked about commissions, it seems like, She talked about some of the contingencies that come in to her income or what affect her income, including some that she couldn't really control, things like market competition, the market itself, interest rates, etc. And I think there was some suggestion that she had called a work colleague to sort of corroborate a few of the things she talked about, but there was no expert evidence to quantify any of it. No evidence to sort of show what the income stream had been historically and what it was likely to be in the future. And there was didn't appear that there was any documentary evidence beyond her income tax summaries. So at the end of the day, despite there was a real injury, but the question was not put to the jury because the court found that there wasn't a sufficient evidentiary basis for it to go to them. So that person lost out on what could have been a significant claim because of that. On the flip side, a case where, again, a recent case dealing with what I think qualifies as a gig type situation is a case called Taylor and Zentz. The citation is 2024 ONSC 166. Like I say, this was a bit more of a physically demanding role, but he was a freelance photographer in the TV and commercial industries, and it's very gig-like in the sense that, as I understood the decision, you literally go from job to job. There's no long-term job. Once you finish one commercial, you move on and hopefully get another one. But Mr. Taylor, what he did was he called a lot of evidence, and I'll go through it in a second. But the court found it was a judge alone decision, so it's always easier to glean what the principles are. But the court found that he had a solid income earning history of about $56,000 and was prepared to accept that as the basis for calculating future loss. But what counsel for Mr. Taylor did, they called numerous work colleagues to testify about what the business entailed, why Mr. Taylor was good at it before the accident, why he couldn't do it post-collision, and the opportunities that he would have had he not been injured. And I guess from what I read, it's a pretty demanding job. And after the collision, he started making some mistakes and literally stopped getting calls. And he called the medical expert to support his sort of functional impairments, and had an expert accountant testify about all of this. So he had, he verified a solid income earning history with documents beforehand, before the accident, and used that to sort of prognosticate into the future to put before the court a reliable sort of income loss theory. And the court accepted it without reservation. It looks like they accepted every last penny of it. So long answer to your question, Timon, is that, you have to, talk to your client, understand their industry, understand their work, and why they can't be successful at it. Talk to people in their workplace or in the same industry to corroborate what your client is saying. This is, of course, from the plaintiff's perspective, and organize your lay and obviously medical witnesses to justify why the plaintiff can't work after the fact. And then, usually, if the claim is going to justify the cost, you want an expert, whether it's an accountant or an actuary or an economist, to sort of tie it all up in a bow and put that clear income loss theory to the court. And what I try to do is, as best I can, is as early as I can, I talk to my expert, my income loss expert, and say, what makes sense here? Like, what can we reasonably put before the jury? If someone makes 20 grand a year, we can't go to the jury with an economic loss claim of $5 million. Like, it has to make sense, and it can't overreach. But anyway, to sort of finish it off, that those are the kinds of differences you see when you're talking about hurdles and the types of evidence you have to call in these cases.
Yeah, that's interesting. Definitely not to take for granted the expert evidence on the income loss piece. It sounds like the first case really turned on that, and I mean there was probably many different elements, but that's a good thing to definitely keep on the checklist for sure.
Yeah, no, it can be frustrating when you read these decisions, because sometimes it seems like because the courts have been clear, you don't need expert evidence to claim income loss, but in a lot of cases, it certainly seems like they want it.
Right. So you always got to balance the cost and but for big claims, definitely something to look into. Okay, so let's turn to discussing collateral benefits and tort thresholds. So there's been a lot of movement here around how courts are handling LTD and CERB and other collateral benefits under Section 267.8 of the Insurance Act. Of course, this has implications for settlement strategy and evaluating litigation risk, especially where deductibility and assignment are in play. So, Joe, I'm bringing it back to you. We're going back up the around this way. How are courts treating LTD and CERB in the context of collateral benefit deductions, and have recent cases really clarified or muddied the waters around 267.8?
Yeah, so starting with LTD, obviously Section 267.8 sub 1 of the Insurance Act says that the insurer gets a deduction for LTD payments earned post-accident against any income loss claim. So that nothing's really changed there, and that's still the case. The one sort of development that hasn't been positive for plaintiffs is the deductibility of LTD settlements. So it used to be the case where if you had sort of a tort auto claim going with an LTD case at the same time, if you settled the LTD claim, there was a good argument based on sort of older cases like Anand and Belanger that the settlement of an LTD claim were not deductible against a tort award. But that has sort of changed lately, and cases are now post-Cadieux in 2016 from the Court of Appeal are now tending towards deducting settlements, or at least a portion of the settlements from an income loss claim. So counsel have to be aware of that on both sides so that the plaintiffs sort of guard against it, and defense counsel ensure that they're getting proper deductions. The only sort of saving grace from a plaintiff's perspective is that on the disability pension front, they've generally been not deductible. So this is a situation where you're eligible for an actual pension, but you have to take it early because of your disability, and you get a sort of a different benefit from that disability pension other than the pension itself. In a case called Finnemore and Hyde, 2021 ONSC 19, found that a disability pension was not deductible and confirmed the law in that regard. So that's a good thing. Quickly on CERB, the case of Ferreira and Hopper, 2024 ONSC 5385. It's one of the only cases I could find on it. The court found that it was deductible. But I think some of it turned on the evidence. I think the plaintiff was trying to sort of suck and blow at the same time. Of course, getting a CERB, to qualify for it, you have to stipulate that the reason you're not earning money and working was because of COVID. So obviously, Mr. Ferreira made that claim and got that award on that basis, but then in his evidence at trial said that he wasn't working because of his injuries. So the court, I think, found that it was deductible. It was income earned during that time, but different facts might support a different outcome in a different case.
Okay, thank you for that. Turning it over now to Chris, continuing on with this topic. So how do the issues of assignment and deductibility play into settlement negotiations, especially in light of what we've heard from Joe now, that the development that it's not settlements are now being set off or are considered deductible?
Well, there's a couple of approaches. We're, as a general rule of thumb, we're reluctant to crystallize a settlement with an accident benefits insurer. Of course, we're talking about motor vehicle accident claims right now. And to settle an accident benefits claim in advance of the tort, because you've crystallized the offset. And, if we can, we'll either deal with them both at the same time, or we'll try and resolve the tort first and the accident benefits second. In the non-motor vehicle accident cases, slip and falls, it's worth asking the question whether the defendant's even entitled to an offset. So if it's a private LTD policy, there's that Cunningham line of cases. So at least in my practice, I find it's a case-by-case basis in terms of negotiations or mediations. And It's not often that I'll get an insurer. In fact, I can't think of one, a case, at least in recent memory, where I've been able to give them the assignment and get 100% of the loss. If I have one bit of advice, it's not even more common sense than anything else, but it's not uncommon for me to hear the insurer asking for 100% of the offset of the future LTD entitlement or income replacement benefit my client's receiving. But they want 100% of the offset, but are only willing to recognize a portion of the damage. So, you can't do both.
Okay, so keep an eye out for those.
Tricky
do the math right. Okay.
That's right. Yeah.
Okay. Warren, this question's for you. In light of this, are parties becoming more strategic with the timing of claims and benefit access? I guess apart from whether you claim before you bring your tort claim.
Yeah, so I mean, it's always important to consider the timing of your claims. So, we've talked a little bit about the settlement of them, and that absolutely is important in terms of set-offs and the order in which you want to settle these. We're all, I think, aware that you don't want to settle your AB or LTD before your tort, if at all possible. There are some exceptions or cases where it's unavoidable, but in terms of the claiming of the benefits, we encounter people who are going through the roughest times in their life. And so, you started off the presentation, Timon, by saying a lot of people are going to ask, what's my claim worth and how long is it going to take? And if you've got someone in your office and the answer to them is this is going to be a 5-year claim, and their next question is, how am I going to survive? I can't work. Oftentimes that's someone that you're going to have to get onto ODSP. Or apply for CPP disability. And so you're creating these offsets early on, which are not ideal, but really are needed in terms of just plugging that cash flow issue that your client has because of the tort they've suffered. ODSP is a bit unique and creates a bit of a problem that you need to turn your mind to early on in a case. When you've got very profoundly injured individuals, if they're still in hospital, they transition from acute care to rehabilitation care while they're in an OHIP funded facility. They're not going to be eligible for ODSP, but that may be someone where you can get the application teed up. So as soon as they're discharged, it's in place to be started. And with people living paycheck to paycheck or who have no paycheck and are just getting a $400 a week IRB, a 1 or 2 week delay in getting those benefits flowing can be a huge stressor. So having that stuff teed up properly is really important. But ODSP, OW, EI, sometimes even WSIB, these are benefits that people will have early on. But if you have a tort claim going, so someone comes to you and they're on WSIB already, you're going to de-elect from WSIB. You can defer that repayment to the end of the case. But that's something that you need to keep in the back of your mind, that there's that clawback coming. EI sometimes is the same situation. ODSP has their processes for going through a ministry exemption, or early on that you need to prep your client for the possibility of a structured settlement or some other mechanism by which they can keep their ODSP at the end of the case, as well as manage the funds that you obtain for them. And OW is usually just going to be a straight clawback. So, a lot of this comes down to the timing of the applications, the timing of those benefits, but also it's a really, really important client management process. Because people, all they feel is the unfairness, quite understandably. They just feel the pinch, they feel the pain, their whole life is in disarray. And if you wait until the end of a case to hand them a check and then remind them of the clawback at that time, you may have done an excellent job, but you're putting yourself in a really, really bad position with your client, where when you talk to them about these things up front in terms of the unfairness of the set-offs, the 267.8 deductions, as Joe was talking about, but you prep that early on. Then when you get them the settlement, you're talking to them in round numbers, square numbers, and they already have in the back of their mind, they know that those clawbacks are coming. So it hurts a little bit less because they've been warmed up to it for a couple of years by that point.
It's all about that expectation setting, right?
Yeah.
Half of the job. Okay, and our last question coming from me, and this is to everyone on the panel. Just generally, what risks should litigators be watching out when dealing with overlapping benefit regimes?
Don't all speak at once.
Thought we discussed in order. I think there's a few things, Timon. You got to understand sort of the deductibility hierarchy in auto cases. So, your income replacement benefit is allowed to deduct LTD and CPP, and it kind of works down a ladder. In not auto cases, you got to watch out for, LTD and your OHIP subrogation claims, depending on the circumstances. So you have to keep a lot of balls in the air when you're dealing with these different benefit regimes to ensure that, certainly at settlement time, but even at trial, that you're presenting the evidence properly. And at settlement, you're taking into account everything, so you're not leaving your client shorthanded. This is a subject of presentations in and of themselves, so it's hard to get into it in that much detail. And I know Warren and Chris want to add something, but just knowing those regimes and ensuring that you're accounting for all of them in your discussions is very important.
Yeah, and you've got a couple common issues that I see is we need to know these overlapping regimes better than the adjusters that we're dealing with. And it's very common, especially on the AB side, that I will see there's two mistakes I see regularly that AB adjusters make. One is that they think that the $400 cap on IRBs is an absolute cap, regardless of what the LTD payment is. So if you've got an LTD payment of $700 a week, for example, a lot of AB adjusters will take the position that there's no IRB payable. However, if that $700 a week, for example, is as a result of a 60% LTD policy, then you still have a 10% top up that the person is going to be eligible for, because it's $400 a week cap up to 70% total. And a lot of AB adjusters just don't know that. And so you may be missing up on that top up, which is really important. Another thing that's kind of similar that happens is if you have a system or a situation of set-offs that's happening and you hit that age 65, your client's still receiving an IRB, they're going to enter that ramp down. The ramp down does not go off the set-off figure. It goes off the entitlement figure before deductions. And so if you got a standard auto policy, even if your client's only receiving $200 a week in IRB because of collateral offsets, the ramp down calculation is off the 400 figure, not off the 200 figure. And that makes a big difference. So those are two really common mistakes dealing with collateral offsets that I see.
Good. I'll just jump in with Ontario Disability Support and Ontario Works. They may provide you with a copy of their file, and buried in there is an assignment where your client has signed an assignment, and you need to be aware if you have an assignment, because it becomes counsel's responsibility to report back at the end of the day with respect to any settlements. If there isn't an assignment, the obligation for payback may still be there, depending on the nature of the settlement. But the obligation rests with the client. So we'll make sure that the client knows about the obligation. We'll offer to deal with it directly for them. But it's a little different if you don't have the assignment. So ODSP, Ontario Works are a couple of areas that we can slip by you.
Yeah. Okay, thank you. And we're coming up close to the end of our presentation today, but we do have a couple questions. I'll try to get one or two of these in. And for the rest, if we've pasted Bergeron Clifford's email address and phone number into the chat, so feel free to reach out and connect with the team here. From Richard Campbell, we have a question. When do you make the decision to retain an economic loss expert or not? Or what are some considerations in determining to retain one or not?
Yes, thank you, Richard. That's a good question. And I think, the boring lawyer answer is it depends on the circumstances of your case. But what I'm doing with my client right from the minute I meet them is I'm trying to understand what their working history has been, and what is the likelihood of them going back to that work in a full-time capacity. So if it's a younger person with a sort of more labor-intensive job who's got pretty significant injuries, that there's going to be an income loss in that claim. Whereas if it's a bit more of a chronic pain, traumatic brain injury type case where we're not sure yet, it might take some time. So I think usually you allow some time for the injuries to sort of recover to a point where you have some reasonable certainty of what the recovery is going to be, and along with the person making efforts to get back to work if they were off work after the accident, or at least settling into whatever work they can or can't do for a long enough period of time that you have some comfort that it's going to be that way going forward. You don't want to spend $10,000 on an income loss report at 6 months if the person's not even close to their full recovery yet. So I think generally speaking, in most cases, it's definitely a year post-accident because it takes that long to sort of get a sense of what the person's going to be. And sometimes it can be even longer. Like if you have a younger client who's in university, it may take a few years for them to really get an understanding of what they can and can't do in the workplace. So it just depends on your case. Those are some of the factors that I look into to answer that question as quickly as I can.
Good. I'll jump in as well. So one of the things I used to do when I first got started was I'd get all my expert reports sort of as efficiently as possible, all in the expectation that by the time I arrive at an examination for discovery, counsel just needed to meet my client, see the merits of the claim. They'd have all the expert reports and they could put a value on it, I'd get it resolved. But what I found was that if I got some of those experts, a future care cost report, an economic loss report, before the discovery took place, experienced counsel would sit there with my report in front of them and just basically ask questions. And eventually, I didn't have an economic loss anymore because they'd be talking about asking questions about being able to, well, surely you can clean your tub with your other arm. I know you're right-handed, but can you use your left hand? And the client would say, yes, I guess I can. So I'll wait for some of these reports until after an examination. The other thing is your own client has crystallized the facts of loss at that point, so you can hand that discovery transcript over to your expert as well. There's exceptions to the rule, but yeah.
Good. Thank you. Well, before we close off, we're going to be putting up a quick poll as well, so our exit poll. We do have time for one more question while people are answering the poll. This one's from Usman. Would the future income loss claim of a gig worker be supported by the AB payments, and would any capitalization thereof as a settlement limit the claim in the tort? I think that's likely one for Joe, but
sure. So I'll answer those in reverse. By capitalization, or I assume you mean the monetary value of any settlement, limit the claim in tort. Yes, under the Insurance Act, that would be deductible. So that answers that question. But to answer the first part of the question, I believe it would. Anytime you can satisfy an AB insurer that there's an income loss to the point where they're paying an IRB, then it's not easy to prove that to insurance companies. So you're telling the tort defendant that there's an inability to work. So I think that's definitely a good thing. I mean, the other part of it, of course, is if the income loss is low enough, then the AB sort of IRB might be paying the whole thing of your pretrial loss at 70%. But it's something that it certainly doesn't hurt. And I usually use that in negotiations to say to the tort defendant, look, even the AB provider accepts that they can't work or can't work to their full capacity.
Okay, well, folks, that's all the time we have today. Thank you, everyone at Bergeron Clifford, for putting this together, answering the questions, and really covering 4 vast areas of personal injury law. So everyone, have a great day, have a great rest of your week, and see you in the future.
Thank you, Timo.
Bye all.
Thanks, everyone.
Thank you.